for delivery of order.
Bail is rejected.
May it please your lordship. Lordship, I beg to mention for listing a bail application for motion for tomorrow, lordship. Bail application, lordship. It's behind the bar for the last 32 days, lordship.
Under which sections?
108, lordship.
Huh?
108, lordship. Abatement, lordship.
32 days.
Lordship.
Tomorrow?
Tomorrow, lordship. Bail application, lordship. Oblige, your lordship.
My lord, I beg to mention item 12, my
Hmm.
Kesda is not available, so my lord,
Serious corporate is not received, issue reminder, list the matter on.
there is interim order that may be considered.
Interim order shall remain in force till then.
No.
14.
14 men. Deeply.
May I please, your lordship, beg to mention for item number 26, your lordship.
Hmm.
CD is not available.
CDS corporate is not received, issue reminder, list the matter on.
Interim is not there. If we-
Oblige. sir.
May I please, lordship. Lordship, I beg to mention item 9, lordship. Counsel for petitioner, Mr. Vijay Das is not keeping well. I think we kindly passed over,
Panel
lordship.
counsel, Mr. Vijay Das is not well. List the matter on.
Oblige, lordship.
May I please, your lordship? Lordship, I beg to mention for listing of a criminal revision petition,
You'll have to
The-
mention before Justice Pages, okay?
lordship. Before pages.
Ah, yes.
May I please, lordship. I beg to mention item number 20. 20 CD is not available.
22,
20.
CDS corporate is not received, issue reminder, list the matter on.
9. It's not 6, after 7.
May I please, lordship, item 17, my lord, 17, my lord. I think Kesdar is not there, my lord. So any
CDS
other
corporate is not received, issue reminder, list the matter on.
interim may be continued. Oblige, my lord.
Interim order shall remain in force till then.
Item 1.
Morning, Your Honor. My lord, the nature of this offense is undeniably grave. Actually, it is 1031.
You need the CD. Charge sheet has been submitted? Or is
Today is
still
the
on
first day
investigation?
actually. I am not concerned whether charges has been issued or not because I am in jail for the last 67 days.
You do not know whether charge sheet has been
No,
submitted?
I have not. Actually, your lordship, I have
Alright,
not
call for the
inquired.
CD, call for the CD, list the matter on. Give it to me.
Oblige.
May I please, your lordship?
Yes, yes.
483 application, my lord. I am behind the bar since 5/3/25. That is 49 days today.
Mm.
The allegation is that I was working with a fake medical certificate in the tea garden. In fact, my submission is that he was working as a male nurse in the garden, and the whole garden was attached to the Tezpur Mission Hospital for all treatment. In the event of any problem, he used to carry the patient as a male nurse to the hospital. But interestingly, the tea garden authority has given a declaration to the labor department that they are having a doctor of MBBS doctor. But he has produced, he was qualified only homeopathic doctor, madam. And alert, the sections has been added that 318(4). My lord, as per the honest Kumar, your lordship could have considered the bail, my lord. And even police
Yes,
could have
yes.
based up to 7 years, my lord.
CD is there.
And 48 and 47 has not been complied with.
Why?
These are the.
Why you're putting lives in peril? Working as a doctor and you're not an MBBS doctor.
Any condition, my lord, 48, 49, 47, 48 has
Short
not been.
date for CD. Short date. Short date for CD. You
It's
have
from
to
Dekha Juni.
call for the CD, list the matter on. Second week.
Second May. My lord, it's quite, today's second May is wrong. He'll complete almost 60 days by that time. Today is 49 days.
Second May, 60 days, you'll complete 60 days.
No, of course, no, 7 days. Let it, first May is holiday. First May is open. Then let it be first May.
Yes, first week.
Item 3.
May I please lodge? My lord, 483 application, my lord. FIR, my lord, page 8, my lord. And this all court has already gone through this case, my lord, in similar, in other accused person, my lord. Page 8 is the FIR.
Under which sections?
Under section 3094, my lord,
309.
94.
You're behind bars for how many days?
27 days, my lord. And the accused person who was named in the forwarding report, my lord, from whose possession, my lord, the alleged, my lord, nuts were recovered, he approved this all course. And you lordship, my lord, order page 20. Other court has also approved this all court. And you lordship,
Robbery, no?
yes, and you lordship granted bail, in some cases in motion stage, my lord, considering the parity, my lord. I am not named, nothing has been recovered from my possession. Alleged occurrence of December 2024. The person who were, my lord, involved, my lord, and alleged nuts were
How
recovered,
many days you are behind bars?
27, my lord,
Others have been behind bars for more days.
36, my lord. The person from whose possession it was recovered. Page 20, my lord. Paragraph 7, he was for custody for 36 days. Page 21. Vehicle has been recovered.
Yes.
Robbery is there, lordship, and they have thrown out the
Sorry.
driver, lordship.
Hmm?
So
Yes.
city is necessary, lordship.
Can be granted, I think. He's
On
behind.
my objection-
And
Yes,
my
you are
objection.
okay.
all several accused has been granted.
No, they were behind bars for many days, much more.
Lot.
More than
This-
1 month, more than 1.5
Lot.
month. But learned counsel Mr. Anali for the petitioner. Asimuddin Ahmed. Who is, LSLS Tinta Asrena, who has filed this application under section 483 of the BNW 2023 with prayer for bail as he is behind bars since 27/3/2025 in connection with so and so PS case under so and so sections. At Mr. KK Das Learned Edition PP Assam. The allegation against the petitioner is that he is involved in a robbery of a drug carrying 32900 kgs of America nuts. 32,900 kgs of Erica nuts. Stop. It is submitted on behalf of the petitioner that the petitioner is not involved in this case. It is further submitted that the prime accused from whose position the drug has been recovered has already been enlarged on bail. The petitioner has prayed for bail on the grounds of parity. The learned additional PP has raised next paragraph. The learned additional PP has raised serious objection stating that this is a case of robbery and without appraisal of CD, a bail in such a serious offense, a bail in such a serious offense cannot be granted. I have considered the submissions at the part. I have also considered the length of detention. I have also considered the fact that 2 prime accused have already been enlarged on bail. It appears that custodial in detention may not be required to further the investigation. Considering all aspects, petition is allowed. The petition is enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the
Chief Judicial Magistrate Morigaon.
under the condition that the petitioner shall number 1, refrain from such activities with which he is alleged. Number 2, the petitioner shall appear before the IO on every fortnight till completion of investigation, and the petitioner shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, bail order shall, he is local
Local.
or from some other place. Last one, we delete food, yeah. Okay, we have deleted the last point. In breach, on breach of any of the bail conditions, the court is at liberty to cancel the bail granted to the petitioner.
He's not, he's from Kamrup, my lord.
We have deleted.
Okay.
May please lordship, for instruction given lordship, the charge sheet submitted, but I am not confirmed lordship. For tomorrow lordship, please tomorrow for confirmation of search.
Okay. Learned counsel for the petitioner has paid for adjournment, leave the matter on. Then you obtain instructions to be obtained.
My name is there or not?
What is your name? Just a moment. Item number 3, no?
Four. Jannatul Haq.
Huh?
And Ahmed.
And Ahmed, no? Yes, yes.
Jannatul Haq name is there or not?
No.
Or instruction.
Yes, yes, Janatul Haq and Ahmed, yes. Instructions to be obtained if charge sheet has been submitted against the petitioner.
Diploma.
Item 5.
May I please, Your Lordship, the 3 years bail lordship. The FIR is very big one, long lordship. The gist of the FIR is that lordship, a truck was apprehended by the police lordship, driver and handyman was lordship arrested. What happened in this case, lordship, 2 number plates were found in the vehicle. So the police suspected the vehicle and thereafter interrogation lordship, they said that they used to carry lordship stolen goods. And they delivered to some of the shop lordship who purchased the stolen goods lordship. Thereafter again police when their lordship picked up them, they also admitted that this truck carries a stolen goods we purchased from them, tires, lordship things, lordship, tires and something stolen things. They also admitted that they purchased from them. Lordship. Now the fact is that
Mobile phone.
I am the owner of this vehicle. Lordship. This is the case. My name also reflects in the FIR lordship. The driver says that I have the knowledge lordship. That is the case. But this is a commercial vehicle. The driver and handyman looks after the vehicle lordship. I am the owner of the vehicle. That is my part.
Yes.
It is necessary because
to
registration is also. Let me appear with the documents and all lots of the vehicle lordship. Because I never run the vehicle lordship. I never drive the vehicle lordship. It is everything is upon the driver and handyman lordship.
No, his knowledge is important, lordship. It can be only ascertained through the CD, lordship.
No, that's true, lordship. I am not denying to that, lordship. But till then, CD come, let me appear with the document, lordship. If something manipulation in the documents may be also there, lordship. Let me go and appear there, lordship. Being a racer, if CD something is there, definitely.
No. Your cooperation is not required. We'll call for the CD.
Only my says that I am the registered owner of the driver of the vehicle, lordship. I never run the vehicle, lordship. It's a commercial vehicle, truck, lordship. If it is in a small car or like that, lordship, it has been different aspect, lordship. It's a truck, commercial vehicle, lordship. The registered owner, lordship, he never drives the vehicle, lordship. Private car, then it would be different thing. Private car, you will go the Faramar vote is a commercial vehicle. Lordship. The deals with information 317 doesn't attract me, lordship. Then is section 33, lordship.
Please read that. Huh?
FR is very long, lordship. I'm ready to read it, lordship.
Yeah, please read it.
Page 10, let us go to the typed out copy, lordship, because it is here. So with due respect, I would like to inform you that on 10/4/2025 in connection with Jorabad so-and-so, on information has been received by IC Jorabad OP from a reliable source that one Tata so-and-so 10-wheeler vehicle using 2 different number plates bearing number so-and-so being using by a gang of thieves.
Why are you using 2 different number plates?
So that's, I'm not the lordship caretaker of the vehicle, lordship. It's a 10-wheeler truck, lordship. I don't even have the license also, lordship, to drive the 10-wheeler truck, lordship. It's a purely commercial lordship vehicle. Using by a gang of thieves, commission of the theft
Are you
like
not ostensibly responsible?
Liabilities is there, lordship. No, liabilities is there, lordship, being the owner of the vehicle, lordship. That is, that I admit, lordship. I cannot deny that part, lordship.
Let us call for the CD.
But till then, lordship, it is 10-wheeler vehicle, I cannot drive that vehicle. I don't have the license also, lordship. It is
Gang of thieves, lordship.
It's purely, lordship, the driver and handyman, those person who arrested, they take care of the vehicle, lordship. And it cannot be taken daily to home also, lordship. It goes far away, lordship, 10-wheeler vehicle, lordship.
Yes, you may be granted bail. Let us call for a CD.
No, till then, Lordship, otherwise if I am get arrested, Lordship, it will be
You are
infectious. Lordship.
arrested.
No, I'll have to run away here and there, Lordship, because though my
Short it,
name is,
short it. You don't have to
though
run.
my name is reflected in the FIR, Lordship. Friday, Lordship, then, if possible. Is from position,
Call for a CD, list the matter on.
Lordship.
20.
Much obliged, your Lordship, much obliged.
May it please your lordship. Lordship, pre-arrest bail application, lordship. This is a charge sheeted matter, lordship. And lordship, in this case, lordship, the petitioner has been shown as an absconder, lordship. Lordship, allegation pertains to lordship, smuggling of those fake gold items.
Call for the.
And lordship may kindly see one thing.
No,
Lordship may kindly appreciate.
Census type of case,
But
fake
lordship,
gold,
lordship, for a
fake
moment.
See,
Lordship, for a moment, lordship. Altogether, lordship, 15 persons have been charge sheeted. 3 have been shown as an absconder.
No.
And lordship has already granted pre-arrest bail. Lordship has granted pre-arrest bail to the 2 absconder accused, lordship. I have annexed the, yes, lordship.
why are you apprehending? I won't grant to bail to
So
him.
lordship will grant, but
All
lordship,
Scan copies of the trial court record along with the scan copies of the CD, list the matter on. First.
firstly.
May it please your lordship. Well, here, my lord. Here, my wife, my lord, has first lost the case against the informant, my lord. Now, my lord, against other counter blast, she has.
376.
Well, lordship may kindly see, my lord, whether there is any allegation of 376. It was, if we admit also, my lord, it is a case between two contexts.
Lordship, I have filed an additional affidavit with this regard, and it is on page number. Page 57 of my additional affidavit, Lordship, in the arrest memo. Of the poet. Page 87, Lordship, there is no mention of the ground of arrest, Lordship, nor any the grounds of arrest has been mentioned to the has been conveyed to the family members of the accused person, Lordship, and which is, of course, Lordship is well aware of the Bihan Kumar and Prabir Purkaisa judgment, Lordship. And apart from this, Lordship, 5 number of witnesses examined out of the 9 listed witnesses, none of them supported the prosecution case, Lordship. On the last occasion, I have apprised before this honorable court the independent witnesses.
How many witnesses have been examined?
5
Out of?
9. And none of them supported the prosecution case, Lordship. And most importantly, from the vehicle, which is from which the alleged contraband said to be seized, does not belong to me, nor there is any investigation with regard to that vehicle, that who is that with regard to the owner of the vehicle, to ascertain the facts, Lordship. And most importantly, the seizing officer, Lordship, already been examined and cross-examined, and on the deposition of the seizing officer, it has been highlighted that it has been brought on record on admission that the mandatory provision of section 42, subsection 1 and 2 of the NDPS Act has been blatantly violated,
No,
Lordship.
that Kasif's case is there now.
Lordship,
The procedural defects will not reshape the trial.
Lordship, the grounds of arrest may be considered at this point, and also the length of detention, Lordship. It's 687 days. I have the citation of the Honorable Supreme Court, Lordship. Like,
Yes, I have with me. You have annexed the citation.
I have annexed
Riyan
only
Kumar's
one
case?
citation. Apart from this, I have this bunch of citation. I can submit before this honorable court. May I read the citation, Lordship? May I read the citations of Bihan Kumar and
Yes.
along with the others? The Bihan Kumar, para 31, Lordship. I'll give a copy.
I have a copy, Bihan Kumar's case.
Apart from
Along with the affidavit, you have annexed the Bihan Kumar's case.
yes. Apart from Bihan Kumar, I have annexed few more citations.
Okay.
After Bihan, not from the Honorable Supreme Court, but from the Honorable Guwahati High Court, the Lordship in Bihan Kumar, para 31, Lordship. The learned special judge unfortunately has equated information given regarding the appellant's arrest with the grounds of arrest. The observation that the appellant of non-supply of the grounds of arrest made by the appellant is a bald allegation is completely uncalled for. All courts, including the High Court, have a duty to uphold fundamental rights. Once a violation of fundamental right under Article 22, subsection 1 was alleged, it is the duty of the High Court to go into the said connection and decide in one way or the other when a violation of Article 22(1) is alleged with respect to the grounds of arrest. There can be possible two contention raised that the arrest of the person was not informed of the grounds of arrest, or B, purported information of grounds of arrest does not contain any grounds of arrest. As far as the first contention is concerned, the person who is arrested can discharge his burden by simply alleging that grounds of arrest were not informed to him. If such an allegation is made in the pleading, the entire burden is on the arresting agency or the state to satisfy the court that effective compliance was made with the requirements of Article 22(1). Therefore, in view taken by the High Court is completely erroneous. And along with this, I have annexed the citations of the coordinate benches, Your Lordship, who has granted bail in NDPS case having commercial quantity on similar footing. The grounds of arrest not being conveyed with them. I have submitted all the citations.
My lord, the scan copy was called for, my lord. We have produced the scan copy, my lord. Lordship may kindly come to page number 46, my lord. Page number 40, there is a deposition of PW5, my lord.
But that now we have this grounds of arrest, this will not
The
work.
grounds of arrest, my lord, I have not found the, my lord, grounds of arrest, my lord. That is the form 50, my lord, in respect of the accused person, my lord.
So
That
it-
may be, that may be called for, my lord, because it is not in the scan copy of the record, my lord.
Lordship, in my record also, there is no Form 50. So the Form 50, the CRPC 50 notice has not been served to the accused person. Lordship.
That cannot be, my lord. Because the co-accused person, my lord, form 50, I have found, my lord. Only in respect of this accused person, my lord, I have not found in the scan copy, my lord.
Even if Lordship, the Prabir Purkasta judgment has vehemently discussed that even if there is Form 50,
is additional,
yes.
Form 50 is additional.
Now, my lord, in this case, my lord, yes, my lord, Dhyan Kumar case, my lord, it is said, my lord, the ground of it has to be furnished, my lord, by including all the particulars of the offense, my lord. Now, in respect of this case, my lord, it is a, my lord, case of NDPS, but this is a special case, my lord. The contraveners,
But in Dhyan Kumar's case, even special act also, we can
No,
grant
that
bail,
will-
even after charge sheet also, we
No.
must, not can, we must grant bail.
but that is true, my lord, that is true, my lord. But in this case, my lord, the witnesses are implicated, my lord, PW5, my lord.
No, this won't work. Even if witnesses have implicated also, because we have this case.
Then, my lord, the ground of arrest may be perused, my lord, but I have not found in the scan copy of the record. Let her produce, my lord, otherwise, let her produce the certificate copy.
When she cannot find, how she will produce?
The question is, my lord, if it is, my lord, not available in the record, my lord, it will be difficult on our part to, my lord, submit that it was not furnished, my lord. If it is there, and my lord, the ground of arrest has not been mentioned, my lord, then lordship may pass necessary order, my lord, for that purpose, I do not have any objection, my lord. But if the, my lord, ground of arrest is not available, that we have to verify, my lord.
May I, Lordship? Lordship, in the Prabir Purkasta judgment, it has been discussed, even if there is section 50 notice, the arrest memo, grounds of arrest in the arrest memo is mandatory. And only on this ground, the arrest memo, it is there, and the certified copy of the arrest memo is there's no mention of ground, which is itself a violation of the fundamental right. Lordship.
Let her produce the certificate copy, otherwise then,
And dragging certified copy of,
ground of arrest.
I have annexed the same,
Put forward.
like the copy.
There's
of the
nothing
certificate
mentioned in the certified copy.
Yes. And
Probably because of judgment, where
Prabir Purkasta judgment, may I read, Lordship, in para 47, in page number 55 of my the bunch of citation that I have submitted right now, para 47. We have carefully perused the arrest memo
page
and
number,
page number 55, Lordship.
Hmm.
Para 47. We have carefully perused the arrest memo and find that the same nowhere conveys the grounds on which the accused was being arrested. The arrest memo is simply a pro forma indicating the formal reasons for which the accused was being arrested. Para 48, Lordship. It may be reiterated that the cost of repetition that there is a significant difference in the phrase reasons of arrest and grounds of arrest. The reasons of arrest as indicated in the arrest memo are purely formal parameters to prevent the accused person from committing any further offense. For proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in any manner, to prevent the arrested person from making inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigation officer which necessitate the arrest of the accused. Simultaneously, the grounds of the arrest informed in writing must convey to the arrested accused all basic facts on which he was being arrested so as to provide him an opportunity to defend himself against custodial demand and to seek bail. Thus, grounds of arrest would invariably be personal to the accused and cannot be equated with the reasons of arrest which are general in nature. In this case, Lordship, bail was granted only because the grounds of arrest were not mentioned in the arrest memo. CRPC's 50 notice has not been discussed at all in this judgment, Lordship, and following which Bihan Kumar has also discussed. And in the Bihan Kumar 50 has been added after the Pravir Purkar judgment. However, Lordship, this judgment already has been is a reported one. The Lordship is well aware, and it has discussed about only the arrest memo, Lordship. Arrest memo, bail application, additional submission. And along with this, Lordship, I have in my additional affidavit, I have filed medical documents of the mother of the accused petitioner who is suffering from cancer and is admitted in the Bibulwa Cancer Hospital. I have annexed the medical documents also. And apart from this, Lordship, in the occasion of Bihu, the accused petitioner has lost his father, which I have not annexed in my petition due to shortage of time, Lordship. However, considering all these grounds, he may be allowed, Lordship. The mother is ailing, having treatment in Bibura Institute, Cancer Institute, Lordship.
All right, let us give him
My lord, what
opportunity.
my landlord friend and my lord submitted, my lord, this is the arrest memo, my lord. This is not the ground of arrest, my lord. My humble submission later produced, my lord, or my lord scan copy of
She
it.
cannot produce.
Then my lord scan copy may be called for, my lord.
Scan copies are there.
Already there.
It is not available, my lord. Ground of arrest, my lord. If she has taken the plea of ground of arrest, my lord, then my lord, we have to look into, my lord, whether it is there or not, my lord.
Lordship, I have annexed the judgments of the citations of the coordinate benches, Lordship. On that same footing, the grounds of arrest not being mentioned in the arrest memo, the honorable coordinate benches have already enlarged. it. Arrest memo should contain the grounds of arrest. In the arrest memo, there has to be a place left for grounds of arrest,
In
Lordship.
Pravir Purkar judgment, but in Bihan Kumar 6 not mentioned. In addition to the grounds of arrest, the grounds of arrest has to be recorded. So contemporaneous record should be there, grounds of arrest, and then in addition to that contemporaneous record,
Yes.
then we have to have this section 50 of the CRPC or 47 of the BN.
Yes.
So
My humble submission, my lord,
sometime.
if she has taken the plea, my lord, then my lord, lordship will have to pass the order as per section 47 or 50 of the CRPC, my lord. Then my lord, the records will have to reveal that the ground of arrest is not furnished.
I'll give you some time. If you want, then I can call for the scan
So that-
copies of the what?
My
Record?
lord, scan copy of the, my lord,
Entire record.
case diary, my lord, case diary.
Case diary.
Case diary, it will do, my lord.
We don't have the scan copies of the case diary. Yes?
It is there, my lord, but that ground of arrest is not available, my lord.
It's a charge. sheet
Because, my lord,
case,
it is a
Lordship.
charged case, my lord, the matter is pending before the trial court, my lord, now.
Already the
So, my lord,
scan
has to
case
be-
has been called.
Has to be called for to registry only, my lord.
To my knowledge, Lordship, there is no notice under section.
Okay, let us find out. We'll give him some 1 week's time, not much,
My
only
lord.
1 week's time.
Well, lordship may call for the fresh, my lord, case diary of the, my lord. Scan copy of the case diary, my lord.
Third learned counsel, Miss
Albany, lucky.
Elboni for the petitioner. The full stop, the learned counsel has prayed for bail as the grounds of arrest has not been mentioned to the petitioner in the arrest memo. Full stop, third learned additional people, Mr. Ajay Burma, who has stated that he that the scan copies forwarded to this court may not contain all the uh, the entire CD and to find out if any notice has been issued under section 50 CRPC stroke section 47 BNSS, the entire CD is necessary. All for the scan copies of the entire CD. Okay,
My lord,
again, Vidya, once more.
next week, my lord, immediately next
Please
week.
the matter on.
They-
Tayo to the 6 May.
Lordship, short date,
Shorter date of the
around 28 or 9, lordship.
Have I rejected his bail earlier?
Not his co-accused bail and
I have
that,
rejected.
yes, that before filing of the,
After 28 and after 28 and before 2nd May, I won't be here.
then 3rd May, lordship.
All right.
Third Saturday.
You see your statement, I have recorded everything. Your submissions I have recorded. I'll keep it in the record.
And then nice.
Accommodate করলে ভালো হলে। আগেও নাই হওয়া, dismiss করলো। Petitioner is not represented today. Full stop. The petitioner was not represented on 3/4/2025. Do you have the CD?
CD not received, my lord.
Bail application stands dismissed due to non-prosecution.
In this case, the petitioners are on interim and they have appeared before the investigating officer also.
You have the CD?
My lord, we have received the case diary, my lord, but their statement is not available in the case diary, my lord. My lord, we have to call for the up-to-date case
Yes,
diary.
yes. Learned counsel, Mr. M.S. Loskar has submitted that the petitioners have appeared before the IO and the statements have been recorded. Full stop. Learned additional PP, Mr. Ajay Burwa has submitted that the statements of the petitioners are not in the CD and the CD is required to be updated. Send by the CD, call for the updated CD and list the matter on. Interim order shall remain in post till then.
Already co-accused granted the civil matter, your lordship. I have annexed the order also.
Without the statements, it's difficult.
Obliged, lordship.
Well, it is 438, my lord. Petitioners are in, my lord, interim. CD was called for.
You have the CD?
Case diary received, my lord. A victim person has implicated, my lord. Then, my lord, injuries are, my lord, sharp and grievous.
My lord, but it is a quarrel between the two brother and sisters, my lord.
And
Both are injured.
they are the FIR name this person.
Yes. First FIR was filed by my.
Grievous injury on which part of the body?
My lord. Left elbow. Then my lord, right labrum. Then my lord, right ankle. What the-
Mr. M H
Chaudhary.
Chaudhary for the petitioner. And learned additional PP Mr. R J Boro. Who has submitted the charge sheet has been laid against the petitioner being CS number.
CS number 6/2025 dated 17/1/2025.
The petitioner is directed to appear before the jurisdictional court stroke Elaka magistrate within 20 days and apply for bail, which will be considered by the court in accordance with law.
Where is the clearest bail application? The injury report and other.
You have the CD?
Yes, there is, madam.
Your lordship, the incident was in the month of October and now the victim was fully fit. FIR is on page 11, lordship. It is humbly prayed that on 5/10/2024 at about 5 p.m. when I along with my nephew namely Zakaria Ahmed returned home from Lakshmipur Tea Garden after plowing a field with cow and buffalo, the above named accused person suddenly attacked us with dao and lathi from the forest and also with intention to kill me. They tried to hit my neck with dao. As I tried to resist their attack, my neck was badly
Yes,
injured.
what do you have? Sahabul Islam. He is the victim and his nephew is the victim. Zakaria Ahmed and Sahabul Islam. Do you have injury? report?
Yes, my lord. My lord, in respect of my lord Sahabul Islam, my lord, he sustained simple injury, my lord. And my lord, as far as the Zakaria Ahmed is concerned, my lord, he sustained simple injury and my lord, grievous injury, my lord, in the head, my lord. Head part is grievous injury, my lord. Other body part is simple injury.
Who has caused the injury?
My lord, both the accused persons, my lord, they have implicated, my lord.
Okay, then rejecting.
Lordship, there are three
Injuries on head.
there are three accused persons. One is already enlarged on bail and incident is on the month
Let
of
me see, let
October.
me see.
And now the custodial detention at that moment.
No, we are not forwarding you to custody.
It's a flag mark that I had you.
You can surrender and apply for bail. I'm just rejecting the bail. You can apply for bail later also. Head injury on, previous injury on head.
Now the victim is fit, fully fit and roaming here and there. We have taken that information.
Fortunately, otherwise he would have died. Okay, I'm rejecting it.
Opportunity maybe there.
At this juncture, you can come later. At this juncture, I'm rejecting it. But learned counsel, Mr.
Yes, that's.
S. Das for the petitioners. We just check their name once. Rajibul Islam, Selim Uddin. Just a
Salimuddin was
moment.
already enlarged on bail.
Already enlarged on.
No,
bail.
Nuruddin was already enlarged on.
I'll just check their name. Rajibul is there.
Rajibul and Salimuddin.
Quota there. Who have filed this application under section 482 of the BNWS 2022 with prayer for pre-arrest bail as they apprehending arrest in connection with so-and-so PS case under so-and-so sentence. Heard Mr. R.D. Purval London, Piasa, who is full stop. The London Additional PP has raised serious objections stating that the petitioners have caused grievous injuries on the head of Jakaria Ahmed, as well as grave injuries on the face of the informant. I have also scrutinized the case diary. Indeed, there are incriminating materials in the case diary against the petitioners. And I have considered the gravity of the offense. At this juncture, there appears to be no justified ground to accept the privilege of anticipatory bail with the petitioners. Petition stands rejected at this stage and by the scene. Later. You have the CD?
Is there a receipt, my lord?
What is the case number? Case number, Neil?
I think on PSK, my lord, when he filed a bail application, my lord, he does not have any information, my lord, regarding register of the case, my lord. So, my lord, we are directed to my lord, so the information, my lord, whether the case has been registered or not, my lord.
Lordship,
Then we
after the
came to know that, my lord, the case has been registered, my lord, and accordingly, CD was called for.
Your Lordship, after the intervention of this honorable court, they have registered the case. But before, the petitioner has been harassed several times. No case has been registered.
Take out yes, case number 31 of 2025. What is the case?
It's an allegation brought up against.
What do you have? What do you have? Yes.
Yes, my lord,
You
there
have
are,
very important.
he is a very for the informant, my lord.
The petitioner has been on several occasions, they have called in the bank also. He have submitted there that he has not made any fraud. After that, they had called upon the police. He also has cooperated there also. And he is ready to cooperate anywhere, anytime. And the entire thing is based on documentary evidence. On that grounds, to send him behind the bar, he will cooperate. Every time they has called upon him, he has cooperated there. In police also, in their bank also.
I do not have a copy of the FIR, so I do not have any idea about the case.
Yes, my lord.
I'll go through the CD. What do you
Yes.
have? PP?
Lord, you may kindly peruse, my lord. I have flag marked the statement of the two witnesses, my lord. But what happened, my lord, they are farm, my lord, they used to collect money, my lord, on behalf of the bank, my lord. Suppose, my lord, there are some private companies, my lord, who gave loan to the, my lord, who purchase vehicles, my lord. Then, my lord, they collect the EMI, my lord. The EMI has to be deposited in the company's account, my lord. But instead of depositing in the company's account, my lord, this accused person is deposited in his account, my lord. And thereby he has misappropriated.
Means, we have to file additional affidavit. where-
Misappropriation.
Misappropriation,
This
huge
is
amount, my lord.
direct misappropriation.
Yes, yes, misappropriation.
Your Lordship, where the company authority has directly said to deposit the fund. There are records also, his bank statement.
Even my lord, when the case was registered, even if he returned the money, my lord, then it would have been different, my lord. Then he has deposited the my lord, amount which was, my lord, credited in his account, my lord, in the company's account, my lord. But he has not done so.
When the petitioner has repeatedly said that I have not made any such fraudulent activity. The company has himself, he has joined. It's on page number 2 of 7. I stated Mr. Kamal Deka joined our company on 24th April 2021 as a team leader based out Guwahati. Considering the performance during employment, our company promoted him as a
Which page, which page?
page number 2 of 7 is FIR.
FIR is not available, no lord, in the lordship record, my lord.
Uh,
Because when this bail application was filed,
yes,
my
yes,
lord,
Not in the record, but in the CD will have, no?
it is in the city, my lord, it's a long FIR, my lord, actually. It's different, but-
Ma'am, based on my performance, they have promoted me as a deputy manager.
This is the FIR, yes.
It is there,
What is?
FIR, man.
FIR along a long.
So what is your ground for bail?
Ground. I will cooperate. This is the only ground, but
You will not cooperate. Because
we have
where
cooperated
you have
several
been
times.
apprehending errors for so many days and then you have not collected the money and then you have
No,
not
no, but-
sent it back to the.
No,
from the-
there are
from
there
your
are
account
some.
To the company's account or
No,
to
no.
the bank's account.
No, ma'am, there are some. We have to file some additional affidavit for that. The bank has directed us to do like that. Even the
You-
general manager.
Have you mentioned in the petition? No.
No, we have
You want
got later
the
on.
additional
Yes,
affidavit.
we have
Then
got.
we'll send back the CD. We'll send back the CD. Then.
In the last occasions, it was fallen from my lords that it is not an appropriate petition, my lord. It will be appropriate for him that he come out with the proper applications when he got the FIR certified copy, my lord. He hasn't done that. And my landed friend, he needs to be very careful when making a statement on oath, my lord. The FIR we have given to the police on December, my lord. And thereafter, an instance from the police, my lord, police has tried their level best. We as a company, my lord, we have put our best efforts to ensure
When
that.
was the FIR lost?
Yes, my lord. Initially, my lord, in the December, my lord, can come to the FIR, which is there in the CD, my lord, on 13/12/2024, my lord,
13/12/2024.
24. And my landed friend,
Petition was filed on?
and then my lord, he categorically stated, my lord, in his petition in page number 2, my lord, that since November, police is after him, my lord. It is his own guilt acceptance, my lord. And we are in the month of April, my lord.
Petition was filed in December, but why didn't you file a copy of the FIR?
The petition,
Petition.
bail petition filed later on, my lord.
Yes, yes.
He has made a statement that police is repeatedly calling and he has cooperated, my lord. Police is after him and company is after him. Please come cooperate. Not this 28 lakhs rupees of defalcation, my lord, alone. There is a Pandora box will come out, my lord. And I am on record, my lord, how they
You
have
withdrawn this petition.
Yeah, Lordship.
You better withdraw this petition,
Yeah.
I believe.
last occasion, my lord has hinted him. Probably he hasn't understood in that perspective, my lord.
Lordship will file a fresh.
And accept the ground, my lord, he has mentioned that police has visited once. Nothing of that sort in the ground he has mentioned, my lord, in the petition, my lord. So my respectful prayer will be at this stage, if he desires, my lord, he can come out with a proper application. Now he got the certified copy, my lord. It will be better for him and the court to appreciate the evidence, my lord.
But learned counsel, Mr.
J. Hussain.
J. Hussain for the petitioner. Learned additional PP, Mr. Ajay Borwa for the respondent state and learned counsel, Mr. A.S. Topada for the informant. To stop, the petitioner has prayed for withdrawal of this application. Petition is dismissed on withdrawal of this petition. Full stop. Petition is dismissed on withdrawal. We will liberty to file a fresh petition. Send back the CD.
Four eighty-two petition, my lord, and the case diary as well as injury.
First, I want to say that here, Lordship, here injury report has come, but in the injury report, it is in the middle part. It is stated here that the patient was primarily treated in GMCH on 16/20. So far, final report, it has not come. Because it is from, it has to come from the GMCH, Lordship. So it is not incomplete, Lordship. However, I can state the injuries, Lordship, it is there, but whether it is grievous or it is not there. So it needs time, Lordship, to update me.
My lord, we discussed going between the siblings, my lord, 6 numbers of siblings, my lord. First number of brothers, my lord, he sold the entire land depriving the other 5 numbers of siblings. And in that occurrence took place in the land of the younger brothers, my lord. Then the petitioner's wife only
CDs are called.
Lordship, two, no,
What
Lordship,
that is?
no, Lordship, one,
Injury reports.
injury is there, injury report,
Only injury reports are called.
injury reports are called for, Lordship.
Call for a case diaries of Jagirod PS case number 240 and 241
240 has come, Lordship.
along with the injury reports. Your case is pertaining to
241,
241.
my lord.
But
241 has come.
240, 240.
But my lord, our FIR file first, my lord, that register letter, my lord.
Then
Madam,
what
but-
to do? What to do now?
Which your case?
There is
Zakir,
241.
241.
241 has not come, Lordship. Then
Then we
another,
will call for the injury
two-
report of your case. We cannot,
Both the cases, in the meantime, my lord, I may.
will not retain.
My humble prayer, my lord.
No, but you see, this case was before Justice Sokia for on 2 occasions. On 2 occasions, you were not granted interim bail. On
In-
2 occasions.
In the manner, he is also.
And then it has come to me, and then I have also not granted interim bail on other 2 occasions.
And, my lord, and extra 6, my lord, series of the injury report, my lord, he is also injured.
What to do? We'll send it back?
Lordship,
Why should we keep this?
this is not related to this case, Lordship, because he is 241, Lordship.
Hmm.
241 has to come then, Lordship.
CD of Patigaon PS or what?
No,
please?
Jagirud.
CD of Jagirod PS case number 240, stroke 2025 has been forwarded. Send back the CD. Call for the up-to-date CD along with the CD of Jagirod PS case number 241 of 2025.
Lordship.
Not 25, not 24, my lord.
Or do it at 24.
Both are good.
List the matter on Jagirod Usota 30 April.
My lord, he is also injured, my lord, and extra 6 series, my lord. Page number
No, but that CD has not
40 to
come.
45, my lord, they are in so many.
CD is of another case.
He
Yeah,
may be allowed.
you are right, absolutely right.
Injured.
You are also injured because there are injury reports.
My lord, both are injured, my lord, that land is to my lord, civil
But
dispute.
unfortunately, we cannot consider your prayer based on that CD. It's true you are injured, no doubt about it.
You know, both the cases, my lord,
But cannot
240,
consider the bail petition on that CD.
my lord, 240 and
It is
241.
believable that you are injured.
Developed.
No, it is not his Lordship, Abdul Qadir. You are not Abdul Qadir.
No, I am against of Abdul Qadir.
Yeah.
Abdul Qadir is the, your old.
Lordship, it
brother.
may be. 30.
240 and 241. Developed.
Petitioner is not represented. CD as called for is not received. Issue reminder. This is the matter on.
Please, your Lordship will find the FIR.
You have the CD?
The FIR is at page 11. The allegation is of the charge, the police have is under rape, my lord. But the FIR says,
আমি খোঁজ খবর করি বিচারি না পাই লোকেল থানাত আৰু বঙাইগাঁও জিআৰপি জাননী দিও খোঁজ খবৰ চলি আছে কিন্তু আজিলৈকে ল'ৰাজনৰ
Nasser Ali, no?
সন্ধান পোৱা নাই মেছেৰ আলী মানে
What do you have in the CD?
Till now, Lordship, as per the CD, the boy has not been found. It has not been recovered, Lordship. Necessarily, firstly, Lordship.
Mhm.
Moreover, the thing is that the wife of this Raham Ali, Hasina, Lordship, and this person, Mr. Ali, they have love relation, though she is the wife of Raham Ali. And this person also know. And while knowing that the secret of this love affair, Lordship, he also threatened this person. And his wife, Raham Ali's wife, has stated that you go outside so that your life will be uncertain. So he go to Delhi, Lordship, and this wife of this Raham Ali called this person, Raham Ali, and he came, but he has never came to Guwahati, Lordship. So this person also, while reading the CD, Lordship, these two persons stated that this Raham Ali asked this wife that let one come the boy, Masher Ali in Guwahati, then you can stay with me. Because after this Raham Ali, Masher Ali went to Delhi, she was beaten up by this Raham Ali and sent to his brother-in-law's house. And the day when he came, Lordship, she came to his husband's house when this person will come. That is also suspicion is there, Lordship. Definitely.
This case, my lord, basically allegation initially was kidnapping. Subsequently, my lord, till date the victim is not recovered. So there is chances to attack another section also, my lord. But in this case, my lord, all allegation raised in the FIR and against me on the basis of suspicion, my
Just a
lord.
moment, please sit down. I'll
My lord,
just
my lord,
read
my
the
lord.
CD.
My lord.
Moreover, Lordship, one more thing, Lordship. In page number 21, it has been rejected, Lordship, this petitioner's bail application. Here clearly stated that the allegation against is that the victim, Masher Ali, through the mobile number so and so. The case diary and records reveal sufficient communication between the victim's mobile number and the aforesaid mobile number, Lordship. These two persons' number.
Not now. Not now. One was granted bail, I think.
I think, yes, my lord, his wife was granted, my lord. What I
She-
want to submit, my
She
lord,
also should not have been granted bail.
what I
Not-
submit, what I want to submit, my lord. In the FIR,
I
my lord,
read the CD, CD, not now.
there is two mobile number mentioned in the FIR. And against this mobile number, informant suspected that the owner of this mobile number kidnapped his son, my lord. I want to submit, my lord, whether these two mobile number belongs to me or not. That part will reveal from the CD,
Get into all those, but not now.
my lord.
This is the, these are some merits of this case. Investigation is going on the strength of that mobile number, so it's not required. to
That
be-
mobile number is not belongs to me, my lord. That is my submission, my lord. And I want to submit, my lord, in this case,
No,
in
no,
connection
no,
with
no.
this,
Now it does not belong to you,
my lord.
but you have bought, sold it to your uncle. All this I'll not mention now.
My lord.
This, everything is there in the CD.
And there is, this is a pre-arrest bail application. I want to, my
And now
lord,
you have
cooperate with the
procured a new
investigation.
mobile number, you have procured a new mobile number for your wife also. So all these are not required to be brought up.
I want to cooperate with the investigation with some protection, my lord. I
In
need to
murder
allow-
case,
My lord,
this will be added, 103 will be added very soon.
my lord.
Our learned counsel, Mr. A.K. Azad,
ठीक है, आजाद।
for the petitioner Roham Ali, who has filed a application under section 482 of the PNWS 2023 with prayer for pre-arrest bail as is apprehending arrest in connection with so and so PS case under so and so sections, heard Mr. K.K. Das learned Mr. P.P. Assam. The petitioner is apprehending arrest in connection with this case as his friend, as his friend Meher Ali has disappeared. Full stop. The petitioner is a prime suspect in the disappearance of his friend who was returning from Delhi. Full stop. The learned counsel for a petitioner has submitted that that only on the ground of suspicion the petitioner is apprehending arrest. Full stop. The police has interrogated his wife as well. I have considered the submissions at the bar and I have also scrutinized the case diary. The merits of this case are not brought to the court as investigation is still under progress. The petition, it is, the allegation is that the petitioner earlier used to work with Meher Ali, who stopped. Meher Ali thereafter went away to Delhi. And while he was returning from Delhi, Meher Ali has disappeared. On suspicion, the petitioner has been interrogated by the police. At this juncture, I am not inclined to grant pre-arrest bail to the petitioner. Petition stands rejected at this stage, send back the CD. Item 24. CDS call for is not received. Issue reminder, list the matter on 6 May.
Lordship, can it be on 5th May, Lordship,
It can be 5th May. And
of next?
Your lordship. Here, lordship, where your lordship will find at page 11 and vernacular lordship may kindly say page 13, it is typed copy. This is filed directly before the court without approaching the police lordship. And in fact, this is a good ground for crossing also, and our high court also in several cases crossed that only on that ground also, even if 376 is there. So I am not on crossing lordship. At this stage, I am on bail. That informant is married person, lordship may kindly see that. And she alleged that one night the accused came to his house as
there is a modification.
Dear,
What kind of modification?
Lordship, at the time of this person was arrested in connection with this
Oh,
case, Lordship.
just a moment. That file has been destroyed. If it's an old case,
Yes, Lordship.
1 year old case, Then according to the rules and orders, the files are destroyed, the files are
Then,
destroyed.
Lordship, the other order in connection with this case,
Do you have
wherein,
a copy?
yes, Lordship, I have annexed, page 16, Lordship. Page 16 is the order wherein this honorable court granted bail to the petitioner
Mm.
along with 3 conditions.
Mm.
One is, Lordship, kindly peruse page 17
Mm.
of my petition,
All right.
Lordship. In last paragraph, Lordship, accordingly, the accused petitioner is allowed to go on
Just
bail
a
on
moment, it read is not fortnight, but it is also পাহৰি যাওঁ না।
Lordship, kindly peruse page number 17.
Yes.
In last paragraph, Lordship,
Mm.
the effective paragraph, bail amount 30,000 with 2 securities,
Mm.
and one of which should be a local one to the satisfaction of this learned CGM Kamrup, with further direction to the petitioner to face the trial regularly without any default. Second condition is, Lordship, he will submit his passport before the learned trial court at the time of execution of the bail bond, and he will not leave the jurisdiction of this honorable court without its prior permission. Lordship, thereafter, Lordship, search sheet has been submitted before the trial court and the case is fixed for hearing on search. And the next date is 2 June 2025. Now, Lordship, this order has been again modified by this honorable court by the order dated 28/1/2022. I have annexed this in page number 34.
Hmm.
The order starts from 34 and effective part is 36,
Hmm.
wherein this honorable court relaxed one condition, wherein last paragraph, accordingly, the applicant is hereby allowed relaxing the condition that on every occasion the applicant need not be required to take prior permission, but he has to give intimation to the learned trial court regarding his absence in any given period and is required to be duly represented by his engaged counsel in his absence. One condition has been relaxed. Now, Lordship, for this petition, Lordship, I have filed to modify the passport which has been submitted by the petitioner.
Okay.
As per direction of this court, page 18.
You
Kindly
have submitted the passport
Yes.
in the CGM code.
Yes, Lordship. In page 18, kindly peruse, Lordship. Page 18.
Yes, I have seen it.
And Lordship, now my prayer is to allow this petitioner to collect the passport whenever he went outside, and after he came back, he will submit the same before the trial court.
Mm.
And the case is at the trial stage, and on every day he is appearing before the honorable trial court, Your Lordship.
Mm.
Order sheets I have been annexed wherein it shows he is appearing in every day. So the prayer is to modify that to that extent that he can take the passport from the court, and after he came back, he will submit the same before the honorable trial court. Lordship. That is the prayer.
In my humble submission, madam, I wanted to tell Lord, 439 is needed for this type of application because it has to be modified. For modification on earlier CRPC, it was 439. Modification of the condition. But here the petition is not with 439.
Okay. Now it's
what-
IA.
Lordship.
No, Lordship. Earlier also, that order has been modified through an IA, Lordship. Page 34.
Yes, I'll have to ponder over it. Yes.
Lordship. Because 439 is specific provision is there for modification of conditions.
439 is, Lordship, for cancellation of the bail order if any
439 too.
439.
Modification is there, Lord.
And
But also-
now in BNS, I don't know which section.
Lordship, earlier also it has been modified
It is there.
In an
Lordship, 439.
IA application, Lordship.
Application
Page
439.
34, page 34, Lordship,
Can be, can be.
can be, Lordship. It is the
But
discretion of
you
the
have
court,
annexed all
Lordship.
the entire, I want a story, entire story. What type of offense he has committed.
Offense, Lordship, we have File the search sheet, Lordship, kindly pay, Lordship. Kindly pay with the search sheet, Lordship, page number 31. Page number 31,
All right.
120B,
So
419.
according to you, that this application has to be under section 439.
Lordship, because in 16 also it is under 439.
16. Okay. Page 16.
16, 439, no, under 4.
That is the original order, Lordship, wherein conditions were put. That is 439 application, Lordship. That is admitted.
By technicality, Lordship, then it has to be 439.
Okay,
Lordship.
I've taken down your submissions. Then you have submitted the charge sheet, no?
Search sheet, Lordship.
I'll have to ponder over this matter relating to passport, because if he'll take the passport, he'll go abroad.
Lord.
And whether he'll return or not, I'll have to ponder about the matter.
Then, Lordship, kindly fix the matter after 1 week, Lordship.
After 1 week,
Yes, we'll
okay.
convince this court, Lordship.
As agreed by the learned counsel as agreed by both the sides, list the matter. 1 week of data needed.
Obliged.
May it please your lordship. This is a 482 application for bail. Anticipatory bail in this case, your lordship. The FIR, your lordship, will find. Page 11.
You have the CD?
We have minor.
Here. Kindly take up the task. This is the translated copy. Page 11, I'll read you. The FIR. It is respectfully submitted that on last so-and-so at about so-and-so, my daughter so-and-so, age is important here, your lordship, 30 years, was rescued under in disposed condition at the bay of the pond near our house. And we came to know that both of the above mentioned accused
Have to prove that they have furnished that grounds, that they have filed their own objection petition also. I do not find anything there. They have to substantiate that claim, Lordship. And now I'm just relying on those citations, Lordship.
How many witnesses are examined?
3 witnesses are examined out of 7.
Out of 7.
Now, whether the grounds, the language used in the arrest memos in compliance with Supreme Court judgment, Lordship may kindly see that aspect, because we have read the conclusion of Bihan Kumar, that is page 21. Lordship may kindly see for a moment, Lordship. Page 15, I have the.
Page 21,
Yes, page 15, Lordship.
page 15 of the judgment or page?
I have there given
15
the
of the
page
arrest.
numbers also, Lordship.
Huh?
I have given my designation is there, Lordship,
Page 15.
page 15. This is of Bihan Kumar's case,
Page 15 of your,
compilation,
okay, okay.
page 15 of the compilation.
Yes.
Yes, just paragraph 21, that conclusion part, Lordship. That number 8, the requirement of informing a person arrested of grounds of arrest is a mandatory requirement of Article 22(1). Now B, Lordship, the information of grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts. So basic facts, there is no facts, only they have mentioned the PS case and the sections. I will come to more elaborately discuss here in the judgment itself. I will come to that also. So Lordship may kindly note that the knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands. The mode and method of communication must be such.
I've read it
Lordship,
5 times.
Lordship, just
Minimum
one.
5 times.
Yes, I have one more thing, Lordship may kindly see that D, clause D, Lordship, that 21D. Last 4 lines, Lordship, I am reading. Needless to add that it will not vitiate the investigation, charge sheet and trial. So trial, as we know, Lordship, that from framing of charges till pronouncement of judgment. So that can, from what I want to submit to Lordship, that if from this observation we can understand that it can be raised before pronouncement of judgment also. Because it said, Lordship, even if initial arrest is held to be illegal, then also trial will not vitiate. So at any stage of trial, we can raise that issue. And subsequent to that, Lordship, but at the same time, filing of charge sheet will not vitiate a breach of constitutional mandate under Article 22(1). And F also, your Lordship knows that
Understood.
stated, just that
Understood, you right?
paragraph 26, Lordship, may kindly see now. That elaboration is there. Paragraph 26, page 17 of my compilation. The stand taken before, Lordship, go ahead.
Yes.
The stand taken before the High Court was that the appellant's wife was informed about the arrest. Information about the arrest is completely different from the grounds of arrest. The grounds of arrest are different from the arrest memo. The arrest memo incorporates the name of the arrested person, his permanent address, present address, particulars of FIR, and section applied, place of arrest.
I've read this. Enough time I have read this.
Yes, so these things will not do.
Arrest memo is not the grounds of arrest.
So if
Arrest
they
memo
have
is separate.
furnished, yes, and in the
Even section 50 is also not grounds of arrest. It is in addition.
in addition, whether they have given any addition to the accused person or not, that is the case, Lordship. Because they have to
So
furnish those.
what you understood from the judgment, I have also understood that
Yes.
it must be communicated in the manner understood by
Lordship,
the person. So
in
you are
writing.
saying that the person did not
No,
understand. that he
in
was
writing.
Carrying drugs.
In writing, he was.
No, that
In
is,
writing is not required. Communicated.
no, that is there, Lordship, in writing.
Where?
Probate Procastor case is there,
The
Lordship,
probate
page
process has
21.
been discussed, no? After discussing this probate processor case, this is the findings. And it was not written that in writing in this case. In
No.
this case, Bihan Kumar's case, nowhere it is written in writing.
No, it is there, just I'm placing for
Only
Lordship,
probate processor's case.
just I'm placing.
And that has been finished before paragraph 15. Discussed and finished before paragraph 13. After paragraph 13, probate processor is not mentioned.
The Probate Procastor case, that part is there,
Yes,
that it
yes,
has to
it
be
is
in
there.
writing.
It is there.
It has to be in writing.
But you are relying on Bihan Kumar, not.
Yes, Bihan Kumar's also on section 50, Lord.
No, your writing is not there in Bihan Kumar.
Yes, Probate Procastor case also, Lordship, Lordship will find.
Nobody has relied on probate processor's case.
No, I have given that page 21, your Lordship will find, page 21
Yeah, then
of my
it's
compilation.
probate processor, it is there. In
Yes,
writing. it
yes,
is in
that
writing.
that aspect has been clarified.
Yes, it is in writing.
So my whole contention for your Lordship is that they have given me the arrest memo without giving the grounds of arrest, Lordship. And from the affidavit or the objection they have filed, they have not substantiated that they have communicated the ground.
It's okay. Last time you gave me this Bihan Kumar's case,
Lordship.
that time you did not give me probate processor's case.
Yes,
It is there in probate processor.
yes, in Probate Procastor's case, it is there,
So last time I have rejected your bail.
Lordship.
Last time I have rejected.
Lordship.
your
Therefore, I have
the
given this
grounds of
compilation
arrest.
also, and even in fact, your Lordship will find
Hmm.
from page 60 onwards, our High Court judgment, all of different benches, I have not given series, no? All of different
Probate
benches.
processor's case is there in paragraph.
Yes.
I forgot the paragraph.
Yes,
It is there. It must
it
be in
is there,
writing.
it is there, that it has to be in
Not-
writing,
You have given me Bihan Kumar's case.
Lordship,
So Bihan Kumar's case from after paragraph 13, there is no probate
Lordship.
processor.
Lordship.
No,
And just one more judgment, I'm just relying on Lordship. Yes, paragraph 19 of Probate Procastor, that.
Para 19,
Para
no?
19.
It is there. It is there. That much I know. I have read that.
Yes. And after that also, Supreme Court also clarified some aspect, Lordship will find at page 51.
And now another case is being fixed for order on grounds of arrest.
Yes, that is written. Yeah.
I don't know. Yes, Roscoe told me.
Lordship,
No, that is in respect of Lordship, whether the grounds of arrest has to be communicated before arrest or after arrest. Because in that article also, your Lordship will find that 24 hours, that is also mentioned. That if it is given
No, no.
within 24 hours, that part will
that
also
part,
see.
that I have to clarify.
I
my lord.
don't know because
That in that,
I haven't gone through live law this.
and
last
I have the
days
copy,
gone
my lord.
through.
I have taken the printout, my lord. That my lord, what, my lord,
The order has not been delivered in the live law, the interaction between the council, the amicus curiae and the court
Who has taken up this matter before the Supreme Court?
Justice B.R. Gawai and
Justice Musia.
The parties?
parties that only hit and run case of Bombay.
Okay.
So that case came up.
That case came up
Oh, yeah,
for
that
again.
I saw.
Yes.
I
Yes.
saw only the highlight I saw. I didn't read it.
Actually, the court is now analyzing because you are watching the same. The PMLA and UPSL case. This ground is being taken and people are going out. It's a, my voice is taken. That's why.
I know his voice is big,
So that's why Supreme Court is.
loud enough, I mean.
Supreme Court is now looking into that DPS and special acts like PMLA and all. Because suppose a murder is committed here, or shootout is carried out in the high court. Now should the police go to Lanaka police station to have a counter arrest and come and arrest him? Supreme Court has said, read the interaction, it says that from the case that the court has to satisfy, we have given this direction. Kumar, but at least we will have, the court has to look into the case diary and see whether it was informed or not. Those are there.
Immediately when you apprehend, you won't be able to give the
Yeah.
ground evidence.
That is we are not
You
disputing.
cannot,
That I am not
So
disputing.
that's why the Supreme Court has now.
especially if you're intercepting on the road.
Yes,
You are chasing a person on the highway.
that is why the 24 hours window is there. That is why 24 hours window is there. They have to
But the
communicate
court is
within
not
24
within-
hours.
Yes.
It's only live law has put on the interaction between the court and the lawyers and the, and then because we have.
Actually, many are getting bail on that ground.
That's ground. That is why, my lord, that is why it has come up, my lord. That is why it has come up, my lord. My lord, the main fact is that, my lord, now the question is before that,
One Tata Harrier and one Scorpio vehicle was detained near Handick College on a secret tip-off that those two vehicles were carrying contraband items from Joraba. During Naka checking, Naka
Page
check
60, 6060.
60. During that petition, like that. During Naka checking, my lord, tablets suspected to be contraband was recovered in from the dickies of the vehicle. Now, your lordship will find that at page 60, the detail of the seizure is given and one mobile number at serial number so and so was one Realme handset bearing IME number with one Airtel SIM card bearing numbers so and so was seized from Mohammed Amir Hussain. Now, investigation was conducted, my lord, and the charge sheet was submitted. The
Oh, this case,
yes, my lord.
one with number and one without number. That there are two vehicles, one Scorpio and one.
Yes, and all the accused
One
persons.
vehicle with number and one vehicle without number.
Yes,
plate.
yes, madam. Your lordship had earlier occasion to go through the city 4 times. And all the 4 accused persons who were arrested have been allowed to go on bail, of course, due to the long incarceration in jail or due to the.
I know this case.
Yes, madam. Now, charge sheet has been submitted. And I have, when the charge sheet was submitted, all these accused persons, they appeared during the trial. Till now, one of the witness, the FSL expert has been examined. And so far, during the investigation, the documents which are furnished to the accused under section 207. My lord, in none of these documents, the name of the present petitioners comes up. But in page 82, my lord, your lordship will find.
Page 82, yes.
Yes. Page 82, your lordship will find that one Manik user of mobile number 600-399-2280. Now, this mobile number was saved in the Truecaller by a person named similar to me by Akramul Islam. Now, my lord, so far the name and number saved in the Truecaller is concerned. Today, if I save my name as Harish, the Truecaller will show everyone my number as Harish. So this cannot be the one of the ground that I can be detained under an NPS case. So they wanted to verify from this mobile number that whether I was in contact.
Which number?
My lord, this at page 82, that top second line 600-399-2280.
Okay.
Because this number which belonged to Manik, who was used by Manik, was in contact touch with my lord the persons who were arrested by the police. Now, so far I am concerned, my lord, I can have, as per instruction, I said that I have never been in contact with this persons who are there, or now during when I was summoned, the police also said that you have financed them. My lord, I am not here. I don't have money to finance them. Both my daughters are suffering from thalassemia, and I'm busy with their treatment now outside in Bangalore. Now I can't even come to Guwahati, my lord, unless I have given some protection. I can cooperate with the investigation. My lord, I don't know what material after filing of the charge sheet. My lord, although they have used the word part charge sheet, my lord, the part charge sheet is alien to the concept of charge sheet. In a charge sheet, it is final charge sheet, but you can conduct further investigation and submit supplementary charge sheet. There is no concept of part charge sheet. I'm not going into those technical grounds, but looking into the facts of the case, my lord, I pray before your lordship that your lordship will look into the materials which are there in the CD. But unless I come and cooperate with the investigation, this subsequent investigation or the further investigation after filing of the charge sheet, my lord, it will not take the police to anywhere. So I pray that your lordship will keep the case pending here and grant me the interim bail so that I can come and cooperate to the investigation. After that, my lord, if your lordship finds that I am the person whose mobile number is Manik, or whose mobile number has been registered in the name of Akramul Islam, then your lordship can cancel my bail and the law will take its own course. But today, considering my precarious condition, I have annexed the medical certificates of my daughters, and me and both my wife and me are outside the state taking care of their treatment. Both are suffering from thalassemia. So on humanitarian ground also, my lord, I am praying that I may be granted the privilege of interim bail. Your lordship will give me 7 days time to appear before the Panbajar police. From the airport, I will come directly to Panbajar police station, cooperate with the investigation, record my statement. After that, they will tally my statement along with the materials which have been collected after the filing of the charge sheet. Then the law will take its own course, my lord. Rather than considering the bail application finally at this stage, my lord.
Okay.
And I don't know, my lord, how the investigation is conducted because I don't have privy. I have privy only to the documents which are there till the filing of the charge sheet. And the police is not powerless, my lord. They can always conduct further investigation. That we all know.
So, trial is also going on.
Trial is also going on, and your lordship, and
This
this
person is, yet to appear.
no, my lord, I have been summoned. But since it is an NDPS case,
Yes.
my lord, any person will be
Yes.
apprehensive because
Yes.
once you go inside, then
Yes.
your lordship, all the,
Custody.
and your lordship,
Below 7 years.
yes, and your lordship has granted bail to all the accused person, considering the long incarceration in jail, and it's only one witness has been examined. 4 accused your lordship has granted. One of the accused person has already expired. Now, next date, the name of the accused who has expired is, my lord, Mohammad Safi, who was granted bail by this honorable court on 15/7/2024. And now next date is fixed for his death report before the trial court. So that is
He
my,
died in the jail, no?
no, after release from custody.
Oh.
After release from custody. And other person also, my lord, I have given the particulars of the persons who have been arrested and all at paragraph number 10 at page 10. They have, they were arrested and forwarded, and later on they were granted bail by this honorable court. Only thing is that today I'm not praying that your lordship will decide this bail application finally. At least give me an opportunity to cooperate with the investigation. Then after that, if your lordship finds that this is a case where my custodial detention is warranted, or at least one opportunity, I pray before your lord.
You are asking for interim bail.
Yes, madam, not final. Only to record my statement because allegations have been made against me that I have that my mobile number is being used to keep in contact with the accused persons. Number one, because when Manik was there, your lordship will see that name is Manik. But if you look into the true caller, then the name of the petitioner is Akramul Islam. Same name as Akramul Islam is there because Truecaller is not a identity, because if I save my name as Akramul Islam, my number also, it will come in the Truecaller. And so for this finance and other parts, there has to be some money trail to connect pay. If I given one opportunity, then I can cooperate with the investigation. My not coming to Assam and staying outside and evading the police process will not take the investigation to any stage. So I am a person who wants to subject myself to the process of law.
Lordship, here in this case, we have received a CD, Lordship, and with the permission of the Honorable Court below, Lordship, and the IO has re-examined interrogated the accused person in the jail, Lordship. One that is the Lordship, Amir Hussain, Lordship. And his statement has been recorded, Lordship, further, Lordship, wherein he has stated, Lordship, that Lordship, this accused, this petitioner has given him 70,000 rupees to give one of the accused person, Musharraf, Lordship.
To whom?
Musharraf, who was coming from some other parts of Assam, Lordship, and he has given that money, Lordship, thereafter, Lordship, and he has also stated, Lordship, in his 161 statement, Lordship, that this person is financing is used to finance them in doing that business, Lordship. And thereafter, Lordship, the CBI report has also been called for, Lordship, and in that CBI report, Lordship, it is revealed, Lordship, that Lordship, there is number of so many times they are in contact with all these three persons are in contact, Lordship. So, Lordship, when there is a NDPS case, Lordship, for anticipatory bail may not be granted, Lordship. Honorable Apex Court has also time and again it is observed, Lordship, in that order. Today I am not available, but in a judgment of coordinate bench, Lordship, that order has been reflected, Lordship. May I place that order? All matters, Lordship.
My lord, in regard to that co-accused statement, my lord, I have an explanation at paragraph number 20, my lord. Paragraph number 20 of my petition may also be kindly seen, my lord.
Yeah, and Lordship, may kindly see that order, Lordship. Para 8, Lordship. Para 8, Lordship, that judgment has been, order has been reflected, Lordship. The learned edition property procedure, that, Lordship.
Okay.
So, Lordship, my humble submission before Lordship, when this is a NDPS case, commercial quantity is involved, Lordship. So, anticipatory bail may not be granted, Lordship.
Okay.
Your lordship may kindly see what has happened actually. This
You
paragraph,
have asked me to look into which paragraph
paragraph 20, my lord,
of what?
of my bill petition. Paragraph 20, page 16.
If required, I can place the
Para 20 of bail.
Yes, my lord, it's a short, I'll read a few lines of it. The accused petitioner respectfully submit that he is not a name accused in the FIR. The name of the accused petitioner also does not find place in the list of the accused specified in the part charge sheet. However, during the absence of the petitioner, the police personnel inquired about him and directed his family members to report to the concerned police station after his return from Bangalore, where he is presently stationed for treatment of his children for his ailments. It is further stated here that during the relevant period when the co-accused were arrested by the police, he was outside the state of Assam in regard to medical treatment of his children. It is apprehended that one of the co-accused has a pending murder trial before the learned court of district and session judge, South Salmara being session case number so-and-so, Mankacha PS case number so-and-so. The said co-accused being the accused petitioner's former classmate neighbor had sought assistance from the accused petitioner. However, upon his refusal to extend any help, it is likely that the co-accused has fallen. This co-accused, who is implicated in a murder case, has sought my assistance. I denied. Then that is the reason he may have implicated me.
So he is in the jail?
He is in the jail in a murder case. I have given the session case number as well as Mankacha PS.
But
Because you are
earlier from this court, he is released on bail.
No. Just a moment. I will check his.
You have stated all the co-accused have been Amir Hussain.
Yes, Amir Hussain was granted bail on 17/12/2024.
But he is in jail because of the murder.
Because of the murder case. And he asked for my help, my lord. That is the main reason. Because otherwise my name doesn't figure anyone.
that I cannot make any comment because it is.
No, that's why, my lord, why I was praying that your lordship will not finally dispose, because this is an NDPS matter. I do not want to trouble your lordship. Only for an interim within 7 days, I will appear before the IO. I'll give all these particulars, including the certificate copies of all this case, this Mankacha PS case and session case number. I'll give it to the IO. IO will look into this act, because a person who is in jail in a murder case, who has been released by this honorable court, and he has asked my assistance, I did not help him. That's why he is implicated.
So this antecedent didn't come up during that bail prayer? I have granted bail.
Yes. No. This was granted by the additional session judge number 1 Kamrup Metro. Probably that was suppressed, otherwise antecedent,
This murder antecedent, nobody will grant.
nobody,
bail.
nobody.
It was suppressed,
Yes,
definitely.
my lord. Otherwise, in a murder case, accused my lord, who is detained and also with
And
a
with
NDPS case,
NDPS.
no chance.
Carrying also the NDPS case also, I don't know, because whether he's,
That
whether
is-
he's a cooperation lordship, that is different thing also. But there may, if there is any other ground lordship,
Okay then, I'll have to ponder over it.
Hmm.
I'll have to rack my brains now.
Yes.
you know.
But I'm not saying because I'm not troubling your lordship to grant me at this final bail. I'm being fair to my learned friend also. He may, I don't know what case law he has cited, but that cannot be an absolute rule that I have during the pendency of this case. One opportunity, my lord, any citizen deserves. If a murder case accused who has suppressed this fact and taken bail from a court, he's playing hide and seek with the court. If he can play hide and seek with the court, then he can speak anything inside in custody. And your lordship knows the evidentiary value of a co-accused who is facing a trial for a NDPS case as well as a murder case. That's a charge sheeted case.
Yes, yes.
That's my respectful submission before you.
Yes.